Hello, everyone. This is Advocate Lucinda, your empowerment lawyer. A couple of weeks ago, I uploaded a video on injunctions. And we learned from that video that when a court orders an injunction, it is either prohibiting a party from taking a certain action or it is ordering the party to take a certain action. And I call the injunction the guardian of civil rights. And I want to talk about another function that I consider also to be a guardian of civil rights. And that's called the declaratory judgment. Once a lawsuit for declaratory judgment has been filed, the court will do two things. One, the court will interpret the law. And secondly, if the court finds merit in the plaintiff's lawsuit for declaratory judgment, the court will declare the individual or individual's rights. And to illustrate this, we're going to look at a case. So you don't want to miss this. So let's get started. Declaratory judgment is defined as a binding judgment from a court that defines the legal relationship between parties and their rights in a matter before the court. When there is uncertainty as to the legal obligations or rights between two parties, a declaratory judgment offers an immediate means to resolve this uncertainty. So let's look at the elements. One, the case must be a case or controversy pursuant to Article 3 of the United States Constitution. So let's recap Article 3. Article 3 of the Constitution establishes the judicial branch of the federal government, including the Supreme Court. It gives Congress power to establish lower courts. The second element, there must be a substantial, immediate, and real dispute regarding legal rights and duties. The third element, the parties must have an adverse legal interest. The fourth element, the requested declaration would effectively settle the controversy. So let's look at case law. Kevin Maurice Rhodes, plaintiff and appellant, versus M. Robinson, an R&R officer et al. That is a 2004 case. So let's look at the facts. Defendant Rhodes, pro se, filed a 1983 action against several correctional officers at the California Correctional Institution in Tehachapi, California. He alleged the officers repeatedly retaliated against him for exercising his First Amendment rights when he was previously incarcerated there. Obviously, he's no longer there. And you can read this at page 563. Specifically, Rhodes claimed that in response to his repeated grievances, and he had many, so you need to read the case, he was retaliated against in the form of the confiscation and destruction of his personal property. In particular, there was a typewriter that they destroyed, which was really important to a pro se litigant, as you can imagine. But in violation of the First Amendment, he contends, and that each defendant and all of them collectively conspired to chill the effect of his exercise of his First Amendment rights through actions that do not advance any legitimate penological goals. And you'll find this language at page 566. On July 15, 2002, the state filed a 12B motion to dismiss Rowe's complaint, asserting that the officers enjoyed qualified immunity because one, Rose was unable to show a chill or deterrence of the exercise of his First Amendment constitutional rights, and two, because it is not clearly established that a prisoner has any constitutional right to be free from retaliatory action that does not chill and or deter the exercise of his constitutional rights. That's a mouthful. You can find the language at page 566. Now, of course, with qualified immunity, we know that it protects state and local officials from individual liability when, unless the official violated a clearly established constitutional right. So the defendants are arguing that the plaintiff is unable to establish a showcase law to support his position that his First Amendment rights were violated. However, in 1982, at least by 1982, the Supreme Court had already established a case, Harlow versus Fitzgerald. The Supreme Court established a prisoner's constitutional right to be free from retaliatory action, citing Harlow versus Fitzgerald. And after Harlow versus Fitzgerald, future courts were able to rely on it in establishing a prisoner's constitutional right to be free from retaliatory action. Does that make sense? Therefore, the current court relied on Harlow and Fitzgerald in making its ruling. So let's go further. On December 2002, Magistrate Judge Dennis L. Beck recommended that the state's motion to dismiss be granted, reasoning that plaintiff makes no showing of a chilling deterrent effect of defendant's actions. And you can find that language at page 566. On January 16, 2003, Rose filed written objections to Judge Beck's report. And I would encourage any pro se who believes that their case has merit and you have the facts and the law to support your argument, that you file objections to the magistrate judge's recommendations. The district court nonetheless fully adopted the magistrate's findings and recommendation and granted the state's motion to dismiss on January 31st, 2003. Judgment was entered on February 4th, 2003, and Rose timely appealed to the Ninth Circuit Appellate Court. Now we're going to get into the meat of the declaratory judgment. The first thing, the judge will interpret the law. So let's see how the judge interpreted the law as it relates to Rhodes. Here is what the court said. A fundamental import to prisoners are their First Amendment rights to file prison grievances. And I cited a case here, or kept that cite in case you want to read it, and to pursue civil rights litigation in the courts. Another case you can read. The court went further. Without those bedrock constitutional guarantees, inmates would be left with no viable mechanism to remedy prison injustices. And because purely retaliatory
actions taken against a prisoner for having exercised those rights necessarily undermine those protections. Such actions violate the Constitution quite apart from any underlying misconduct. They are designed to shield. Powerful language. You can read it at page 567. The court continued, within the prison context, a viable claim of First Amendment retaliation entails five basic elements. Remember, that's what Rose sued for, violation of his First Amendment rights. One, an assertion that a state actor took some adverse action against an inmate. Two, because of three, that prisoners protected conduct and that such action, four, chilled the inmate's exercise of his First Amendment rights, and five, the action did not reasonably advance a legitimate correctional goal. And you can read that at page 568. Powerful language. So now we're going to hear what the judge declared in regards to Rose's rights. Rose alleges that they arbitrarily confiscated, they being the defendants, the officers, arbitrarily confiscated, withheld, and eventually destroyed his property, threatened to transfer him to another correctional institution, and ultimately assaulted him. Two, because three, he exercised his First Amendment rights to file prison grievances and otherwise seek access to the legal process. And that four, beyond imposing those tangible harms, the guards' actions chilled his First Amendment. And five, their actions were not undertaken to advance legitimate penological purposes. Rose's First Amendment complaint is, in short, this is the court's declaration, the very archetype of a cognizable First Amendment retaliation claim. Powerful. There's more. In this context, the court continues, and at the pleading stage, we have never required a litigant per impossible to demonstrate a total chilling of his First Amendment rights to file grievances and to pursue civil rights litigation in order to perfect a retaliation claim. Speech can be chilled even when not completely silenced, because it would be unjust to allow a defendant to escape liability for a First Amendment violation merely because an unusually determined plaintiff persists in his protected activity, as Rose did. Rose does not have to demonstrate that his speech was actually inhibited or suppressed. Rose's allegations that his First Amendment rights were chilled, though not necessarily silenced, is enough to perfect his claim. His claim being that the defendants violated his First Amendment rights. In summary, the judgment of the district court is hereby reversed and the case is remanded for further proceedings consistent with this opinion, says the Ninth Circuit Court.